The most important financial invention in history wasn't the stock or the bond, it was the legal person that can't go to jail. Think about that for a moment. Somewhere along the way, we created an entity that could own property, sign contracts, sue and be sued, but could never be imprisoned, never truly held accountable the way a human being can be. This invention, the limited liability corporation, fundamentally altered capitalism and society itself. It's a story about how we transferred risk from those who profit to everyone else, and in doing so, created monsters we can barely control. To understand how we arrived here, we need to go back to a time when doing business meant putting everything you owned on the line. In the medieval period, if you were a merchant and your venture failed, creditors could seize your home, your possessions, everything. Business partnerships meant unlimited personal liability. If your partner made a catastrophic decision, you were on the hook for all of it. Who would risk their entire family fortune on a voyage to the Indies that might never return? The answer emerged with the Dutch East India Company, founded in 1602. This wasn't just a company, it was part business and part government. The Dutch government granted it extraordinary powers: the right to wage war, negotiate treaties, establish colonies, and mint currency. But the revolutionary aspect was its structure. Investors could buy shares, and their liability was limited to the amount they invested. If the company collapsed, creditors couldn't come after shareholders' personal estates. This was radical. Suddenly, wealthy merchants could invest in risky ventures without betting their entire livelihoods. The British East India Company followed, receiving its royal charter in 1600. These early corporations were special privileges granted by monarchs, not rights available to anyone. They were monopolies, tools of empire building wrapped in commercial enterprise. The British East India Company would control vast territories in India, maintain its own armies, and function essentially as a sovereign power. It committed atrocities, caused famines, and enriched shareholders while devastating entire populations. And, when things went wrong, who went to prison? Occasionally a scapegoat, but never the entity itself, and rarely the investors who profited most. This is where the fundamental problem reveals itself. The corporate form created a separation between ownership and accountability. The investors who benefited from profits were insulated from consequences. They risked only their investment, not their liberty or personal assets beyond that investment. Meanwhile, the corporation itself, this legal fiction, couldn't be imprisoned. It could be fined, dissolved, or sued, but it couldn't experience shame, remorse, or the deprivation of freedom that serves as society's ultimate deterrent. For centuries, this arrangement remained relatively constrained. Corporations required special charters from governments, which could be revoked if the corporation acted against the public interest. In early America, corporate charters were granted sparingly, often for specific public purposes, like building a canal or bridge, with strict limitations and sunset clauses. There was deep suspicion of concentrated corporate power. Thomas Jefferson warned against banking institutions and corporations, fearing they would subvert the republic. Andrew Jackson went to war against the Second Bank of the United States, viewing it as a threat to democratic governance. But the Industrial Revolution changed everything. The scale of industry required massive capital investment that no single individual or traditional partnership could provide. Railroads, steel mills, oil refineries, these enterprises demanded thousands of investors pooling resources. State legislatures began passing general incorporation laws in the mid-19th century, allowing anyone to form a corporation by simply filing paperwork and paying a fee. The corporate form became democratized, which sounds positive until you realize what it meant: the proliferation of entities with limited liability and growing power. Then came one of the most consequential legal developments in corporate history. In 1886, the Supreme Court case Santa Clara County versus Southern Pacific Railroad included a headnote stating that corporations were persons under the 14th Amendment. This amendment had been adopted after the Civil War to protect freed slaves, ensuring that no state could deprive any person of life, liberty, or property without due process. Somehow, this protection was extended to corporations. This designation opened a floodgate. If corporations were persons, they could claim constitutional protections. Over the following decades, this concept expanded to grant corporations free speech rights, religious liberty rights, and protection from various regulations. The Supreme Court's Citizens United decision in 2010, which allowed unlimited corporate spending in elections, rests on this foundation. Corporations gained the rights of persons without the responsibilities and vulnerabilities that constrain actual persons. Consider the asymmetry this creates. A corporation can live forever, outlasting any human generation. It can grow to enormous size, operating across borders, wielding influence that rivals nation-states. When it causes harm, polluting a river, selling a dangerous product, exploiting workers, it might pay a fine that represents a tiny fraction of its revenues. A cost of doing business. The shareholders are protected by the liability shield. The executives might face some consequences, but often they've been compensated handsomely and can simply move to another corporation. The entity itself continues, perhaps under a slightly different name after a strategic bankruptcy. The history of corporate malfeasance is really a history of externalities, costs imposed on society that don't appear on the corporate balance sheet. The corporation privatizes profits while socializing risks and harms. This was true when the East India Company helped addict China to opium to balance trade deficits, causing millions of deaths. It was true when American corporations dumped industrial waste into rivers, turning them toxic. It was true when tobacco companies hid evidence of cancer risks for decades. It was true when financial institutions packaged fraudulent mortgages, crashed the global economy, and received taxpayer bailouts. That last example, the 2008 financial crisis, perfectly illustrates how the corporate form enables the too big to fail phenomenon. Large financial corporations had made reckless bets, engaged in fraud, and created a house of cards that threatened the entire economic system. The rational response might have been to let these corporations fail, to let shareholders and creditors bear the losses, as market discipline would suggest. But these entities had become so large, so interconnected, so central to the economy, that their failure would have caused catastrophic collateral damage. So government stepped in with trillions in bailouts, transferring losses from private investors to public taxpayers. The executives kept their bonuses, the corporation survived, and many became even larger through consolidation. Some individuals were fired, a handful prosecuted for lesser crimes, but the fundamental structure remained intact. No corporation went to prison because corporations can't go to prison. The corporate veil held firm. This is the ultimate expression of privatized gains and socialized losses, and it's only possible because of the legal architecture we've built around the corporate form. The environmental crisis we face today is perhaps the clearest example of how corporate limited liability enables massive externalities. Fossil fuel companies have known for decades that their products were causing climate change, threatening the habitability of the planet. The profits flowed to shareholders. The costs, rising seas, extreme weather, displaced populations, ecological collapse, are borne by everyone, especially those least able to afford adaptation. The death of personal liability, the insertion of the corporate veil between ownership and consequence, represents one of the most significant legal and social innovations in human history. It enabled unprecedented economic growth and complexity. It also enabled unprecedented harm, concentrated power, and the transfer of risk from those who profit most to society at large. We created a legal person that acts in the world with tremendous force but cannot experience the ultimate sanction our legal system imposes, the loss of freedom. These entities are neither good nor evil. They are goal-seeking machines optimized for profit within whatever constraints the law imposes. But when those constraints are weak, when the corporate veil shields owners from real accountability, when corporations are granted constitutional rights while avoiding constitutional responsibilities, when they become too big to fail and too powerful to effectively regulate, then we should not be surprised that they behave like monsters. We designed them that way. The invention of the corporation killed personal liability, and in doing so, we created something we're still struggling to control, something that may ultimately control us instead. The question we face is whether we can reform corporations to restore balance between power and accountability, reconnecting profit with responsibility, and ensuring real consequences for those in control. If we fail, risks remain socialized, profits privatized, and the monsters we've created grow ever larger. The invention of the corporation was revolutionary. Whether it becomes our undoing depends on whether we can muster the will to remake it.